things to begin with. A long time ago, when my third daughter was being born, my two daughters came to class with me. They were little, 4, 5. And when we went back and saw their mother, she said, what was it like? Well, we went into this big room and Daddy just started shouting. And that basically sums up my style of lecturing, that I go around and shout and I wander, and hopefully everybody can hear me, although that's never been a problem in my career. I'm very pleased to be here today. I'm especially pleased that it's Saturday rather than Sunday, because one of my passions in life is following English football. And there is a huge game tomorrow morning. And if it had been this morning, boy, that would have been difficult. This is Manchester United play Liverpool. It's a very big game. I'm very excited about it. Okay, what am I going to talk about? Well, I'm going to talk about, in praise of great cases and great judges, traveling with the common law. So what I want to try and do is to talk about law and how it moves and how it develops. And contrary to what many people think, I don't want to talk about law as a static body of rules. I want to talk about law as an activity. Law is something that lawyers do. It's not just what's left over after they've been doing what they do. Law is in the actual engagement and operation. It's an organic process. It's a work in progress. And so we need to think about that. And like any human activity, it involves the interaction of character and circumstance. And although it may appear rather esoteric from the outside, law, I think, is just a bunch of people trying to deal with other people's problems. Sometimes they do it well, and sometimes they don't do it well. And they have no special great insight, these people, in my view. They're talented people, but they try to do the best they can. Sometimes the best is good enough, sometimes it isn't. So I want to mix up the idea of great cases and great judges. And so I'm going to draw upon, this is where the commercial comes, on 2 books that I published recently. One is about great cases, and the title of the book, as Lorna Marsden said, is called Is Eating People Wrong? And that's based upon a famous case from the 19th century about people being stranded at sea and killing one of their number in order to survive. And the answer to the question, is eating people wrong, is, well, it's not a good thing to eat people, but it's just a kind of food and drug offense. It's not a big deal. It's when you kill them first that you get into a lot of problems. And in this case, they were convicted, but ultimately given clemency. I also published a book called About Great Judges. It was a follow-on to Great Cases, and it was called Laughing at the Gods. And I'll try and explain why I used the phrase laughing at the gods. So what I'm going to do today is really tell the story of a very famous case. In fact, many lawyers would say the most famous case in the common law. Now, by the common law, we talk about a certain family of legal systems, which can be contrasted with civil law, or other countries can rely upon religious law. But the 2 main ones, certainly in the West, are the common law and civil law. Civil law is based upon a code, and the judges apply the code, which is a fairly extensive, elaborate document, to various disputes that come up. The common law is entirely different. The common law, not easy to explain what the common law is. It's an assembly of cases which lawyers draw rules from, and they're bound by the idea of trying to continue the tradition of the common law and look to the past in order to decide present disputes and to lay down rules for future conduct. It's as I'm trying to show, an organic process. And quite interestingly, although it's based on the idea of continuity, the great cases tend to be those cases that broke with tradition. Big cases. And the one I'm going to talk about today is a case called Donoghue and Stevenson. And it's a case about a snail. It's about other things, but it's also about a snail. And one of the questions in the case was there a snail? Which we'll get to. So I'm going to tell a story about what happened. And I should say let me get this right, in May, I was in Glasgow, which is where this case takes place, and it was the 80th anniversary of this case, and we visited all these spots where apparently Mrs. Donahue went and the factory where they developed some of the products. It's great. It was in a place called Paisley, just outside of Glasgow. Paisley's famous for... Pardon? I don't know who said this. Paisley. Yeah, that's good. What's Paisley? That's very clever. What's Paisley? Yeah, the clothing design, right? That was where the Paisley pattern, which became sort of, in the middle of the 19th century, it was designed, but it had a resurgence in the 60s. It was very much part, which is why Jeff knows it, it's very much part of the hippie culture, right? Which is what I associate you with, right? So Paisley, Scotland. When I was there, Paisley is one of those towns that made its wealth, its reputation in the 19th century, and has now seen better days. It's a little down at edge. There's some wonderfully grand architecture. But anyway, Mrs. Donahue. Maid Donahue is a strange person to become one of the iconic figures of the common law. She had a very tough upbringing. She was one of 10+ kids. She became pregnant in her teens and was obliged to be married. She had many other pregnancies with a man. She was originally called May McAllister. She was married to a man called Donahue. He did not treat her well at all. And in fact, as she moved into her late 20s, just before this case occurs, she went to see a lawyer for the first time in her life in order to get a divorce. This was the only time she'd ever been in a lawyer's office. And in August 1928, she took a bus ride from Glasgow in the Gorbals district. Now, if anybody knows about the Gorbals district, it's quite nice today, the Gorbals district, but in the 1920s, this was your classic slum area. And she went out to Paisley. This was a strange trip for her because it was a little posher in Paisley. She was going there because she had an invitation to go to a newly opened ice cream cafe. So it was very fancy in 1928. Glasgow. Now, one thing we're not clear about is whether this was an invitation from a man or a woman. People scoured various archives and records. We've no idea what it was. But she went out there on the bus to Paisley, and on the main street, she went to a place called the Well Meadow Cafe. The Well Meadow Cafe, or CAF, as people like to call it in Britain, was a newly opened ice cream parlor. And it was owned by a man called Thomas Mincella. And Thomas Mincella was originally called Franco Mincella. He was an Italian immigrant. There's a strong Italian community in Glasgow, and he was part of that, and it opened what he would call a gelato store, but in fact, it was ice cream. She went there with her friend, and the friend insisted that it was her treat. She said, I'll come back to this, it's a very important legal point. It was her treat. So she ordered an ice cream float, which was basically 2 scoops of ice cream, and then they poured on top of it ginger beer. She ordered this. Thomas Mincella, the owner, was also the kind of waiter and the everybody in the cafe. He came out and he poured half the ginger beer onto the ice cream float. She ate part of the ice cream, chatting away with her friend, and then her friend, seeing that most of the ginger beer had gone, poured the rest of the ginger beer onto the ice cream. And at this point, allegedly, out popped a snail. A decomposed snail was in the ginger beer bottle. This upset Mrs. Donahue. Now, exactly what happened after this, we're very unclear about in the day or so. But she felt ill. She went home. She decided she had to go to the Glasgow Royal Infirmary. This would be a big step for her in 1928. This is pre-welfare state, the National Health Service in England. She must have been extremely ill to do this. She goes there. She just started a job as a shop assistant and, in fact, spent a couple of weeks off work. And not really thinking much about it, she went back to work, relieved that her illness was over and ready to get on with the rest of her life. Now, as many people here in this room will testify, and I've been rather delinquent here. As I've been talking away, I should have been showing you some slides. So this is May Donahue. It's a later photograph of her. We have no photographs of her in 1928 when this took place. And this is sort of blurry picture, which is in the middle of the Wellmeadow Cafe. This is all knocked down now, and there's a plaque on the sidewalk which tells you that's where it is. Now, many people in this room, let alone in 1928, have been into some kind of restaurant and found something in their food. It's not unusual now, let alone in 1928. Right? I mean, is anybody here never ever been to some kind of eating establishment and never found something in their food? Really? You're very special if that's the case. Just a couple of hands. I mean, I've had some incidents where you do that, and you usually talk, usually complain, they'll bring you another dish of whatever it was, they maybe won't charge you, the usual stuff. I had an incident involving some beer, where I opened a beer and it really wasn't good. I went back to the beer store. I was in a good mood when I went to the beer store. I said, look, one of these in this 12-pack, and the guy at the beer just said, hey, what can you do? I said, come on, you got to do better than that. And then you're in a kind of argument. He said, okay, I'll give you another 12-pack. I said, I want more than a 12-pack. I want a 24. You have to decide at what point you're going to say you're a lawyer, right? And all those things. So you try and I ended up with about 28, about 36 bottles I got. Because I hadn't been injured. You'll remember there was a case recently whereby, this is not for the faint of heart, a woman went into a McDonald's, bit into a hamburger, and there was a rat's head allegedly, in the hamburger. Now, the difficulty for this woman was, two problems. She actually wasn't ill. She wasn't actually affected by this, and she gave away her biggest card from a legal point of view, which was she told people about this. Right? The best thing she could have done is tell no one and then go and talk to McDonald's. And McDonald's would have started panicking at that point. But once the information got out, McDonald's really, no point in doing anything with this woman, right? Because all the damage had been done. So these are classic situations. I also had a student in a class, this is a sad comment on law students, who after I'd given this kind of talk, came to see me and said, look, I got up the other day, I had a loaf of bread that I'd put in the freezer, I got the loaf of bread out, I cut it in half, and in the middle of the bread, came from Western Bakeries, was a mouse. But he was delighted by this. He hadn't eaten it, and he saw, dollar signs coming up, and wanted my advice about what should he do. I said, well, you can do lots of things. You can play this for money, or you can be more public-spirited and go to the public health department, because if there's one mouse, there's got to be more than one mouse in the bakery. He decided, being a student, that he wanted the money, and so the one thing he had to trade was not going to the public health officials, and he never told me how much money he got, but he did. He got more bread than he'd originally bought. Anyway, back to Mrs. Donahue. Now, Mrs. Donahue would have been happy to go on. People in 1928 and people now don't just go and see lawyers. Right? Many people don't see lawyers. But in this case, an important figure entered into the story. And this was a man called Walter Leachman. Walter Leachman was a lawyer in Paisley, and he was on a campaign. He was a kind of Ralph Nader. People know who Ralph Nader is in the States? Pardon? The spoiler. The spoiler. Well, what did Ralph Nader do? Yeah, he was a guy, he's an activist on behalf of what we might call consumers, and he'd go after various car companies, big cases, to try and hold large manufacturers to account for what they do. He also goes after big tobacco, but big industry generally. Now, Leachman was annoyed by the level of food production in Paisley. He should still be, if he was alive today, he should be. One of the signs in Paisley you see is deep fried Mars bars, right? It's one of the delicacies of Paisley. Anyway, Walter Leachman had spent a number of years before this incident going after the soft drinks industry, which he thought were particularly bad. And he brought a number of cases and lost. And I'll explain what loss means in a minute. But he heard about, through a strange set of exchanges, Mrs. Donahue, and he tracked down Mrs. Donahue. Mrs. Donahue was very troubled about, why would I want to get involved you know, this happened, I went to the hospital, I'm back at work. And he persuaded her that she should get involved and that they should bring a case against the manufacturer of the ginger beer. He also told her that he would hold her harmless in the sense that it would cost her nothing. Because this was a great fear, that he said to her, you'll get money if we win, but of course, being fairly wise, Mrs. Donahue said, but what if we lose? And he said, well, there's nothing to worry about if you lose. And he was that kind of campaigning lawyer. And to me, this is a huge part of the story, because without Walter Leachman, this case wouldn't have occurred. It might have occurred later in a different way. So what happens? What does he decide to do? Well, first of all, there's the problem of cost, right? He has to absorb a lot of this cost himself. He knows it's not cheap taking these cases, but he was a man on a mission. He also applied in those days for what would be the equivalent today of legal aid. And it was to have Mrs. Donahue designated a pauper. So she actually got funds from the state, which would give money to Leachman, but also if this case went on, they would be able to employ other lawyers. And that's another part of the common law. It's not free to bring cases. The best cases don't come forward. The best cases that people can afford come forward. And also, even if you've got a good case, you need a defendant that's got some money. There's no point in winning cases if the other side's got no money, right? So in this case, he worked out, well, the soft drink industry has money, and we can access that money. So, just let me get my glasses a second. So, who did they decide to go after? Well, they found that, having talked to Minchella, that in fact, there was a bottle. And this was the bottle. You'll see at the top there's a little snail coming out. So the bottle says Stevenson, Glen Lane, Paisley. And this was 600 yards away from where the cafe was, and was a supplier, allegedly, to the cafe. The important part of this is, one of the important parts is, this is an opaque bottle. Right? There's no way you could inspect the bottle and know there was a snail in it. This became important, and I'll say something about that in a second. And one of the allegations was there a snail in the bottle? Because Stevenson, first of all, denied that it was his bottle. Second, he said, even if it's my bottle, which has got my name on it, there is a practice that even though the first use of the bottle originates with a particular manufacturer, the bottles tend to go back to other manufacturers. And he says anybody could have filled up this with ginger beer, and it certainly wasn't me. They were a fairly established firm. Leachman wanted to go after them because they were established. They weren't a fly-by-night operation. And ginger beer in those days was partly alcoholic. And one of the things that was true was there was a large amount of sediment in these bottles. There was yeast that they were using in these bottles. So they decided to go after Stevenson. And Stevenson has what lawyers today would call deep pockets. Right? You need to go after people with money. Which is the way lawyers talk about people with money as having deep pockets. So he decides to bring an action against Stevenson. Now, I have to talk about a bit of law. Why is this important? It's 1928. The thing we have to remember is that the person who bought the bottle and the drink was not Mrs. Donahue. She had not given value for the product. The person who'd given value was her friend. Her friend could have sued. She could have sued initially for being given a defective product. But all that would have entitled her to was the price of the bottle, because she'd not been injured. All that had happened was she wanted a good bottle of ginger beer, and she got a bad bottle of ginger beer, and so they would give her the price of the bottle, which is nothing. Right? Mrs. Donahue, though, is the one who's injured. But Mrs. Donahue didn't have a contract either with the cafe, and certainly not with Stevenson. Therefore, the novelty of this case, and why it became a huge case, is, do you have a claim against someone if you have no contractual relationship with them? Do they owe you a duty to take care? So in this context, it's about, do they have a duty to provide products which are safe and non-defective? And in 1928, the answer to that was likely no, which is why Leachman was bringing these cases. He said, surely we should hold these manufacturers to account. They can't be putting out any kind of crap into the market, right? One way to hold them to account, we can lobby for legislation, but that's a difficult process. And the manufacturers are much better organized to prevent legislation occurring than lone consumers like Mrs. Donoghue. But Leachman was keen to get them. He thought, we're going to go to the courts. So the basis of the claim was a duty owed by Stevenson, regardless of contract and the exchange of money, to the ultimate consumers of the product? Now, presumably today we think, yeah, like how could this be disputable? In 1928, this was big stuff. So he brings the case and he pleads that the bottle was bought by Mincella, the owner of the cafe, from Stevenson, that it had a snail in it. The snail came out. This caused Mrs. Donoghue to be ill. Now, Stevenson's initial response to this was that, one, it wasn't my bottle. If it was my bottle, I didn't put the ginger beer in. If there was ginger beer in it, there wasn't a snail in it anyway. Right? And the difficulty was they were going to have trouble proving there was a snail because nobody kept the snail. Right? When they left the cafe, nobody was thinking about a legal action. Right? They just left. And the snail and the rest of the ice cream just got thrown away. So he makes those allegations. But in an important legal development, he said, look, even if you can prove that there's a snail in that ginger beer and she became ill as a result of that, there's no legal claim. There is no duty owed by a manufacturer to the consumer of products. And he said the action should be struck out. Right? And so the case went forward on what we would call in law a pleadings case, simply saying no cause of action was disclosed by the facts. Stevenson said, even if you proved all the facts, you've got no cause of action. And the case went forward just on that basis. Even if the facts could be proved, was there a cause of action? Now, when the case first went to trial, on that point alone, that legal point, no evidence was offered. Right? They just said, even if it were proved, there's no case. The first judge at trial said, well, maybe there is a possible cause of action sufficient for us to get this case going. And then we'll find out later on whether, in fact, there was a snail and everything else. Stevenson appeals this to what is called the Court of Sessions in Scotland, in Glasgow, and 4 judges, 3-1, decide that there is, in fact, no cause of action. That even if Mrs. Donoghue can prove all those facts, she's got no cause of action. Now, at this point, it becomes difficult for Leachman, because Leachman is faced with the fact that the next step is to go to the highest court of appeal, which is in London. And there's an aspect to this I'll talk about in a minute about Scotland, England. It's a big thing, Scotland, England, if anybody's connected to that. But he would have to go to what's called the Judicial Committee of the House of Lords, which is the highest appeal court in the United Kingdom. To do this means big money, right? Because he's not going to argue the case. You have to get what are called QCs or KCs, depending on who's on the throne, which is King's Counsel or Queen's Counsel. These cost money, these people. And he then made the decision that he would go, that he thought he had enough of a case that he had a chance of winning. And he also thought the only chance of winning is to get it before the House of Lords. Now, I'll say something about the House of Lords shortly. So, one of the first issues that came forward is he gets 2 lawyers. They're called Morton and Milligan, who happen to be Scottish but work in London. And they argue the case. They argue the case before a bench of 5 judges who are called law lords. These are not lords who then become judges. These are people who are judges, and once they get to the top court, are given a peerage. This has only changed in the last 3 or 4 years, because the highest court in the United Kingdom now is called the Supreme Court, similar to our own. However, the judges voted to keep their titles when they moved over to the Supreme Court. So there's usually about 13 law lords, and they sit on a bench of 5. And argument is fairly informal. They don't wear gowns or anything. They wear suits. Needless to say, in 1928, they're all guys. How many women have been on the House of Lords since 1928 up to 2012? I mean, it's only 2012 after all. There's been one. So that's pretty depressing, to say the least. So the first issue the court has to decide is, because Stevenson's lawyers say, you got to decide this under Scottish law, not English law. It's a Scottish case. It's all about a civil code. But the courts say, well, we're going to assume for the purposes of this appeal that Scottish law is the same as English law. Now, Scottish lawyers go crazy about this even today and say that just cannot be right under any circumstances. Scottish law isn't English law. But they hate English law, right? About this. But the law lords, of which there were 2 Scots in the panel of 5, said, no, we will assume Scottish law is the same as English law. So the case went off on that basis. And it was argued just over a couple of days. And then the House of Lords reserved judgment, which simply means they go off and take time in how to decide. We don't have much about how the 5 judges interact. The received wisdom is that each of them just goes off and writes their own judgment, and then they see who's won. Right? I don't believe that. I think they do talk about these cases. They do strategize about what they're going to do, and that's certainly true today. It's certainly true in the United States. You can read book after book about the kind of deals that go on in the United States of the 9 judges. There's a famous book in the, I'm guessing the 80s, by Woodward and Bernstein of Watergate fame, but it was called The Brethren. There's no women at the time. On the US Supreme Court, about the kind of horse trading that went on between the judges. We have less of that in Canada, but we have it. People do these empirical studies and show that certain judges never vote with other judges. They always tend to vote with the same judges. They always tend to be on the same side. And they make deals between each other. People will like that or not. Now, at this point, I should say something about the great judges, because one of the judges, or 2 of the judges in this case, can claim to be great judges, one in particular. So what is it to be a great judge? So my book is largely about what does it mean to be great at anything, let alone judging, and who might claim to be great judges in the common law tradition, of which I name 8. For me, a great judge, maybe it's easy not to talk about judges or lawyers, but to talk about other fields, literature, art, sports. Sport's one of my things to talk about. So in sport, what does it mean to be a great athlete? Well, in some sense, it means being better than everyone else, right? But that's not enough, I don't think, to be great. Right? To be great, you've got to beat the records, right? But you've got to do something else. To me, to be great is not only to beat everyone else, but to change our understanding of what it means to be a good player, right? Or what it means to be a good artist. So someone like Picasso could not only do what other people could do, he changed our understanding of what it was to be a good artist, right? And you can think of literature, and this is my definition, it's not some canonical view of what it is, that great people are those who change our understanding about what it is to be good in a field. They're not just good, they're not just very good, but to be great, things are never the same after they've done what they've done. Right? So that's my understanding, right? So, you know, I think of something like, say, boxing. Muhammad Ali was a great boxer, not just because he beat everyone, but he changed people's understanding of what it was to be a heavyweight boxer, right? I could go through a sort of variety of things, right? And you can pick your own topic, whether it be art and literature, and think about who are the true greats. Because by definition, they're going to be a handful. We're talking like 2 or 3 over 150 years, 200 years. So who are the great judges? Well, interestingly, the common law is supposed to be a tradition of change, but incremental change and continuity. But the great judges tend to be those who've imposed their vision on the law, and they've changed people's understanding about what it is to be a good judge. And one of the people who did this was one of the players in this case. But let me talk a little bit more about great judges. And it's a good point here to have a kind of interlude. Now, hopefully this will work. So, one of the things we have to be careful of with great judges, whoever undertakes to set himself up as a judge of truth and knowledge is shipwrecked by the laughter of the gods. If you want to be a judge, you've got to be real careful here that you don't claim hubris. You know, that you can see the world and you know the answer to everything. Great judges, I think, recognize you can't make that claim. So, here's a different way of thinking about judging. Now, people may know this is a guy called Peter Cook. He was part of Beyond the Fringe. People know any of this? It's kind of Monty Python-esque, but not the same. He used to be with a guy called Dudley Moore. Right, so this is Peter Cook. Now, hopefully, it will play, and hopefully you can understand. If we can't understand it, I've got a slide that tells you what he says.
Yes, I could have been a judge, but I never had the Latin. I never had the Latin for the judging. I didn't have sufficient to get through the rigorous judging exams. They're very rigorous, the judging exams. They're noted for their rigour. People come staggering out saying, my God, what a rigorous exam. But I managed to become a miner instead, a coal miner. Managed to get through the mining exams. They're not very rigorous. They only ask you one question. They say, who are you? And I got 75% on that, so... One day I was walking along in the dark. I saw the body of a dead pit pony. I went in surprise. Ever since then I've been going unexpectedly, and that's another reason why I couldn't be a judge. It destroys the dignity of the court, you see. A whooping judge is not very much welcome, but I wish I could have got into judging circles, because the trouble with being a miner, as soon as you're too old and tired and ill and sick and stupid to do your job properly, you have to go. Well, the very opposite applies with the judges. So all in all, I would rather have been a judge than a miner, because I've always been after the trappings of great luxury. I've always fancied them. Yet I've got hold of the trappings of great poverty. I've got hold of the wrong load of trappings. And a rotten load of old trappings.
So, that's Peter Cook. Not everybody's style of humour, but I like this kind of stuff because I'm English, right? In lots of ways. So, what is it to be a great judge, right? What do these people do? Well, that's the clip. It's quite interesting about the kind of nonsense that judges talk, because when we look at who the great judges are, they tend to be real characters who stand out, impose themselves. But recently, and by recently I mean early 2000s, John Roberts became Chief Justice of the United States. And he's been a very important player. He's a very smart man. There's a book just come out by Jeffrey Toobin, which is all about the interaction between what he claims are the two smartest lawyers in the United States at present. On the one hand is John Roberts, who's Chief Justice, and the other one is, he's also a Harvard Law School grad. You all know him. Yeah, Barack Obama. Barack Obama's a lawyer. He was not in the same class as Roberts, but they're pretty close, right? And they're claimed to be the two most talented lawyers, and he explains the interaction between the Chief Justice and the President. When he was asked early 2000s about what made a great judge, Roberts said this: judges are like umpires. Umpires don't make the rules, they apply them. The role of an umpire and a judge is critical. They make sure everybody plays by the rules. But it's a limited role. Judges have to have the humility to recognize they operate within a system of precedent shaped by other judges equally striving to live up to the judicial oath. It's my job to call balls and strikes and not to pitch or bat. Right? Now this is kind of the received wisdom about what judges should do. They're not playing the game, they're just judging the game. But anybody in law would know he couldn't possibly believe this. I mean, this is, to put it politely, disingenuity by Roberts. Another way to put it, he's just lying. He can't possibly believe that his job is to call balls and strikes. Right? Law changes all the time. Why does it change? Because of the judges we have. We have the law we have because of the judges we have. And in fact, what he did on the healthcare reference, I'm not going to go off on that, but was very much about Roberts taking a very political role and switching from the conservative side to the more liberal side. So in this case that I'm going to talk about, there were two famous judges. The first is this guy who's called Lord Buckmaster. He was actually called Stanley Owen, but Lord Buckmaster sounds much better. So, Lord Buckmaster had received his title through his father. His father was a self-made man. He started off as a nobody, made a fortune, and then received a peerage, which he passed on to his son, Stanley. Stanley, however, went on to have a stellar career as a liberal politician, and he became Lord Chancellor of England. And the Lord Chancellor of England occupies a very strange position. He or she, there's never been a she, he is the highest legal officer in the country, the same as our Chief Justice. But he's politically appointed, and his appointment changes with the government. Once the government falls, the Lord Chancellor ceases to be Lord Chancellor, and he's a member of the cabinet. That's true today. So you're both top judge and a member of the cabinet. In the States, you can't do that because of the Constitution. They would find that a ridiculous breach of the separation of powers, as we would, some people say. The idea that the Chief Justice would also be in the cabinet, many people would think would be ridiculous. However, it's not as strict as you think in Canada. So the head of state in Canada is the Queen. The Queen. Got the Queen. And her representative is obviously the Governor General. But sometimes the Governor General is out of the country, for fair reason, and somebody has to step in. There is no deputy Governor General. Who becomes Governor General and signs legislation off when the Governor General's out of the country? The Chief Justice. Now, I've obviously led that way because of what I've said. Many people don't know that. But it's strange. One day, and it's a she in Canada, Beverly McLaughlin, is signing off on legislation, and the next day she's judging the legislation in the courts. It's a strange process. There are lots of others in Canada. Okay, so Buckmaster, and this is an interesting part. He was quite a liberal guy. He supported in the 20s a lot of liberal, and by liberal we might think of progressive initiatives. He was very high on women's rights, at least women's rights within the context of the 1920s. Right? He also was reasonably supportive of the unions, again within the 1920s context. And when he heard the case of Mrs. Donoghue, he has become the villain, because in his judgment he finds against Mrs. Donoghue and in favor of Stevenson. He says Stevenson does not owe a duty to the world to make his products any good. Plus the fact, if you don't pay for the product, you shouldn't get any rights anyway. But the reason he did this has been overlooked, I think. He did this not because he was a rank conservative. He did this, first of all, this was the guts of his judgment at the top. There can be no special duty attaching to the manufacture of food apart from that implied by contract, which remember Donoghue didn't have, or imposed by statute. If such a duty exists, it seems to me it must cover the construction of every article, and I cannot see any reason why it should not apply to the construction of a house. Now, we read that today and think, he's trying to use that as a kind of reductio ad absurdum. Gee, if we allow a duty here, people who build houses might be liable, as though, wouldn't that be wild? Well, when we read it now, we think, yeah. You know, he goes on to say, surely if the roof falls down, should the builder be liable? And we would say, yeah. But he didn't think so. But then he uttered a very famous phrase, if one step, why not 50? If we go down this road, he says, we're never going to stop. Now, history's actually proved him right. Right, once they started going down this road, they've gone a long way. So he says, yet if a house be, as it sometimes is, negligently built, and in consequence of that negligence the ceiling falls and injures the occupier anywhere else, no action against the builder exists according to the English law. Then a nice little bit of xenophobia, although I believe such a right did exist according to the laws of Babylon. So the whole idea is you'd be nuts to give this kind of duty. So this is Buckmaster. However, Buckmaster said that the reason he did this, and he says it later in his judgment, is because he doesn't think judges should be doing this. If you want to make these kinds of changes, it's for Parliament. It's not for judges. Judges are not elected. They don't represent anybody. They should just apply the rules. So he argued after this case that he actually wasn't against doing some of these things. He was only against it being done by the courts. Now, fortunately, he only persuaded one of the others to come on his side. So he only got 2, which left the other 3 going the other way, who found for Mrs. Donahue. And the leading judge who gave one of the great statements of the common law was this guy, Lord Atkin of Aberdyfi. He was called Richard Atkin, known as Dick to his friends, and he is acclaimed to be one of the great judges. It's also, if you're writing a book about great judges, it's also convenient the fact there's a great backstory to this guy. And I think you need to understand the backstory. One of the things that we tend to do today is we know there are 9 judges on the Supreme Court of Canada, but nobody knows who they are. I mean, some people would know some of them, but most people don't know who they are. And my view is, you need to know who they are. They're not faceless individuals. Right? We need to know who they are because they're making the law. Right? We need to know Beverly McLaughlin's the Chief Justice. You need to know a bit about Beverly McLaughlin. Right? She's not making judgments in spite of the fact that she's Beverly McLaughlin. She's making them not entirely because she's Beverly McLaughlin, but that's got to be part of the mix. Right? So, what about this guy? Well, this guy was born in Australia. His parents, Robert and Mary, emigrated to Australia in the 1850s to try and break away from the UK, set up in the new country. They initially intended to set up a sheep farm, but Robert fell off a horse and got injured. And as most fall off the horse sheep farmers do, he became a politician. But to become a politician, he was supported by a local businessman in Queensland, in Brisbane, called William Hemnant, who supported Robert in his political career. He became quite famous. He had children, of which Atkin was the oldest. He had 2 other siblings. But in a way that we're unclear about, the marriage started to fall apart. And it so happened that a couple of years later anyway, the father died. But 2 years before that, Mary left Australia and went back to the UK. She went back with 3 kids. This was a rare move for a woman in the 1860s. It was early 70s, about 71, 72. She went back and they moved to where she came from, which is Aberdyfi in Meirionnydd in Wales. And Atkin's life began there. He was only 4 or 5 when he got there. And his life was very dominated by women. He was brought up by a single parent, his mother. But they also lived with the mother's mother, the grandmother, who's known as Nine in Welsh. And she was a very dominant individual, had a huge effect upon Atkin. I should also say he was dominated women because he had 6 daughters as well, and a wife, right, to fit in. So women played a huge role in his life. And he grew up in Aberdyfi, sort of lower middle class family. And as many people, he was a very smart boy, and he went to Friars College in Bangor, where I think, like for many people, this is certainly, I'm not comparing myself to a great judge, but for me, there was a teacher who saw more in me than I saw in myself, or anyone else, and he for me, had a huge part in if I've been successful in being successful. And the same happened to Atkin. There was a man called Mr. Lloyd, who took Richard under his wing and got him moved to a much better college called Christ College in Brecon. And he went from there on to Magdalen College, Oxford, where he studied classics, and then he decided he wanted to be a lawyer. So he went to one of the Inns of Court in London. There are 4 Inns of Court in London, if people know these. There's Gray's Inn, Lincoln's Inn, Middle Temple, and Inner Temple. You have to be a member of one of these inns in order to become a barrister. And Richard Dick became a member. He qualified, became a barrister. I did the same thing. But barristers have to be self-employed. You can share offices, but you can't become partners. And if you haven't got a source of getting cases, you're going nowhere. And he was struggling to get cases. He was thinking maybe he should stop being a lawyer. And then, who does he run into? But he runs into William Hemnant. The person who'd sponsored his father in Australia had moved to London. And when he ran into Hemnant, he also ran into Hemnant's daughter, who was called Lucy Elizabeth. And as things unfolded, he married Lucy Elizabeth, who had been born 12 days after him and 100 yards away in Brisbane, Australia. Now that's quite a coincidence, in my view. And in marrying Lucy, and by all reports they had a good relationship, he wasn't a gold digger, because he got lots of work then through his father-in-law, and became a prominent lawyer, and went from there to be appointed to the bench and became a member of the Law Lords. And he gave many famous judgments, but his most famous judgment is in this case of Donoghue and Stevenson. And this is what he said. In English law, there must be and is some general conception of relations giving rise to a duty of care, of which the particular cases found in the books are but instances. And then he says something that all law students need to know by heart. So I'm teaching this case next week in the law school for my first year class. The rule that you are to love your neighbor becomes in law, you must not injure your neighbor. Now, there's a story behind this. One of his 6 daughters went on to be a lawyer, and she wrote a biography of her father. And she tells a story, who knows if this is true. She said, Dad used to come home, and we always insisted we all dine together, and he used to say what he'd been doing that day. And she said, I remember him coming in home and telling the story of Mrs. Donoghue about the snail in the ginger beer bottle. And he said to his daughters, what do you think should happen? And being the precocious kids they were, and Bible-loving children, they quoted from one of the Gospels, which says, love thy neighbor. And apparently, Dad Atkins said, that's it. And he went off and he wrote his judgment based on what one of his daughters had said at dinner. Now, this could be apocryphal, who knows, but the daughter insists that it was true. But it also gives us a good insight into in how judges operate. They operate because they're part of the world, they talk to people, they get different ideas, and in this case he thought, that's a hell of an idea, right? You're supposed to love your neighbor, so in law this means don't injure your neighbor. He also gave a lecture at King's College London a couple of weeks before he did this judgment, where he talked about this. He sort of gave it a dry run to see if he'd get any response. And then he went on to say, who is my neighbor? Well, it receives a restricted reply. You must take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbor. Who then in law is my neighbor? The answer seems to be persons who are so closely and directly affected by my act that I ought reasonably to have them in contemplation as being so affected when I am directing my mind to the acts or omissions which are called in question. And this is the source of all what is called tort law in the last 80 years. This is a resounding statement of principle. And its great attraction is not that it's precise, but that it's imprecise. Right? You can read this and go to a lot of places with this. It's one of the great attractions. Some people compare it to great literature, you know, like to be or not to be. That's great, right? Because the idea is it gives you a tone, a direction, but it doesn't really spell out where you're supposed to go. Right? So this remains the basis of the law today. Atkins' statement about the neighbor principle is one, like I say, I'm teaching this next week, and students have to know this. And it influences what's happened in the 80 years since. So Lord Atkin was one of the great judges. Let me say a few more things about him before I talk more about the case. and then allow people some time for questions, is Atkin gave many judgments. And perhaps his second most famous was a case called Liversidge and Anderson, which has great resonance today. In the early 1940s, middle of the war, the executive started the executive meaning the government, started locking up people if they didn't like them, particularly if they were foreigners. This resonates with, Guantanamo Bay. You go and put people up, you don't like them, you just lock them up. And you give no reason why you're locking them up. And Liversidge brought an action, he had a different name, saying that the government had to give reasons about why they were locking him up. And the government said, the executives, no, we don't. As long as we're not acting in bad faith, we don't have to give reasons. And there's no evidence of bad faith. There were 5 law lords. 4 of them found for the government. Right? And said, no, the government don't have to give reasons. Just like the cowardly US Supreme Court today, who do the same thing. You don't have to give reasons, you just lock people up if you want to do. But one judge stood out, and that was Atkin. And he said, that's just not right. You've got to give reasons. Government can't act without observing the rule of law, and that requires reasons to be given. And the executive, like everybody else, are answerable to the courts. Now, he came under enormous pressure from the other 4 judges. Right? And in fact, his refusal to go along with them meant the 4 of them never spoke to him again. He was, now, within that kind of elite society, this was heavy stuff. Right? And the phrase in English would be, they sent him to Coventry. If anybody's heard this phrase, strange phrase. But it means, exile, silence. Now, he died a few years after that, but he was prepared to take the slings and arrows, what he thought was taking the right view. He believed, his great claim to be a great judge was, he wanted to protect the ordinary person. And he thought, if the rule of law can't protect the ordinary person, it's not worth what it is. So Atkin was a great judge, and he gave this judgment, and he found in favor of Mrs. Donoghue. And he said, whatever happens in the future, if you ask the question, who is the neighbor of Stevenson? The answer is, well, those people so closely and directly affected by my act that I ought reasonably to have them in contemplation. It's hard to imagine that wouldn't be the drinker of the ginger beer. Whoever else might be owed a duty of care, the ultimate consumer in this case surely is owed a duty of care. And they say that Mrs. Donoghue therefore was owed a duty of care. So I'm going to wind this up in 2 ways. First, I'm going to say, so what happened after this? So bear in mind, all we've done so far is to say, if the facts are proved, she could win. So then they had to go right back to the beginning and start arguing about the facts. Because Stevenson said, right, there was no snail in that ginger beer. It wasn't my ginger beer anyway. So they set a trial date. This judgment is given in May 1932, and they set a trial date for later in 1932, but as things would have it, Stevenson died. And there was never a trial. His estate, which means the people who represent him after his death, paid her £200. He was quite a wealthy man, Stevenson. He had maybe 15,000 on his death. Right? They paid her £200 to close the case. This was a huge amount for Mrs. Donoghue. But there was never a trial, and we have no idea whether there was a snail in the ginger beer. And Stevenson went to his grave saying that there was not a snail in that ginger beer. Thomas Minchella, the owner of the cafe, he was already out of business by 1932. Fancy ice cream salons weren't working out in Paisley because they like deep-fried Mars bars instead of ice cream. So what happened to Mrs. Donoghue? Well, Mrs. Donoghue is a bit of a sad tale, really. She left Glasgow, went to live with one of her daughters. She then suffered a considerable amount of mental illness, and she died in 1958 at the age of 59. Not really knowing that she had become this icon of the law. Now, I haven't got time to do what I was going to do next, but because I think it's better if we ask questions, and you've heard enough of me anyway. But one of the things is, well, what's happened since? Right, 1932 and beyond, what's happened? Who can claim? Right? So one of the questions is, who is the duty owed to? Is it just consumers, right, that's owed the duty? Who else can make claims against? What if somebody went off and washed their hair in the ginger beer? Right? Some people use beer for shampoo. I don't know why you'd use ginger beer, but if you did, can they claim if it goes wrong? If you start putting the beer in a cake and somebody eats the cake because the train's getting further and further away, can you do that? Against whom can you claim? Is it just manufacturers? Can you claim against public authorities? Can you claim against the government? Do the government owe you duties of care to take care of you? And so laws developed to look at who can make claims, against whom can the claims be made. There's a very famous case in 1964 that said, well, does this apply to statements? What if people make negligent statements, you act on those statements to your detriment? An obvious group would be, who makes statements? Sorry? Politicians, maybe. Who else? Advertisers. Financial advisors, right, are the big group. Accountants, lawyers. If you go and see a lawyer and they give you advice, and the advice, it can't just be wrong, it's negligent advice, can you sue them? And the answer, as in most cases in law, is maybe, right? Maybe. It depends. Another discussion is, well, what kind of losses can you claim for? Because in the statement cases, you're not claiming for personal injury, which is what happened in Donohue Stevens. She got injured. You're claiming for economic loss. Is economic loss the same as personal injury, or should there be different rules? And the law's gone on hundreds of cases trying to work out distinctions between statements, economic losses, as compared to personal injury. And that's how the law's developed. And the last one is, Steve Atkins said, acts or omissions. So he says on there, you must take reasonable care to avoid acts or omissions. Are you responsible for omissions if you fail to do something? So the classic case is, you're walking by a lake and somebody's drowning. Do you owe a duty of care to try and perform some easy rescue, not massive heroics? Or can you just look and say, well, that's tough, and walk on? Right? Now, you can be morally criticized for walking on, but the law actually says you have no legal duty to rescue anyone, unless there are 3 exceptions. Well, I can remember all 3 here. 1, if you negligently created the peril, then you do have a duty to try and save. If you have a special relationship with the person who needs saving, the obvious example of that would be children, right? But there's examples where if people go out on a boat and one of them falls overboard, the others have a duty to rescue, whereas passing ships have no duty because there's no relationship. And the third one is, if you begin a rescue, you've got to carry it through. You can't just get halfway there and think, whoa, I've had to change a plan. Also, rescuers, if they act negligently, are liable for injuries they cause to people they're rescuing. So the law's gone on about that. And so I'm going to end by saying, all I've wanted to convey in a sense is a different sense of law than what I think many people have. I could be wrong about that. That it's just about learning rules, cramming your head with rules, applying rules. It's an incredibly human process. And because of that, it's flawed. Right? They don't get it right. Right? There's a continual argument about this stuff, and we try and push out the boundaries, or we push a little here, and then we push there. So it's about that interaction between historical circumstance and characters. And in this case, the characters were not just the litigants, May Donohue and David Stevenson, but the lawyer, Walter Leachman, about the judges, Stanley Owen and Richard Atkin. These are some of the figures of the law, and so if you want to know about the common law, think about it in these terms. It's just a human process with all the benefits and all the flaws of that. And that's me finished.